Hello, my name is John O'Toole, and I'm here to talk about employment discrimination. Employment discrimination is a subject near and dear to my heart. I see it more and more often. It's becoming more and more prevalent in the workplace, unfortunately. Prior to opening my own practice, I worked for an insurance company that was the first carrier to provide employment practice discrimination coverage for small employers and large publicly traded companies. It's good coverage, and a lot of employers buy it today. Now, there's a couple of takeaways I want you to keep in mind, which I'll repeat at the end. Number one is that you have to exhaust all administrative remedies. You cannot go directly to court. Number two is you must bring your complaint within 180 days of the last act of discrimination, not necessarily when you were fired, the last act of discrimination. Number three is that if you file a complaint with the Illinois Department of Human Rights, it's automatically cross-filed with the Equal Employment Opportunity Commission and vice versa. So it makes no difference initially where you file your complaint, which leads us to the next question. Which way do I go? Do I file the complaint with the Illinois Department of Human Rights, or do I file the complaint with the EEOC? I believe for most people, the best avenue to file is with the Illinois Department of Human Rights, and here's why. Firstly, with the EEOC, you have to show a substantial limitation in mobility. With the Illinois Department of Human Rights, all you need to show is an impairment that is caused by a medical or mental defect. That's it. It's a very low standard. Under the Illinois Department of Human Rights, the state can go after what's known as aiders and abettors outside the organization. Under the EEOC, you're limited to your employer and your employee. The third criteria is a size limitation. With the Illinois Department of Human Rights, you can go after and sue your employer in sexual harassment and retaliation for up to 20 employees. With the EEOC, you have to have greater than 20 employees. The second reason is under age discrimination. Age discrimination kicks in for those 40 and over. With the EEOC, you have to have more than 20 employees. Under the state law, you can have less than 20 employees and maintain your action against the employer. There are a couple other things to keep in mind as well. With the Illinois Department of Human Rights, what they're looking for is some substantial evidence of discrimination, and that usually means some type of discriminatory contact or some type of discriminatory intent, which is manifested by acts or conditions imposed by the employer. You have what's known as a right to sue letter. Let's say after the investigation, the Illinois Department of Human Rights finds out that they do not have a basis to proceed, or they don't have the wherewithal because they don't have enough people to pursue your claim. They will issue what's known as a right to sue letter. This leads us to another very important discrimination factor, and that is that you have 90 days to pursue your act or your charge. If you miss the 90 days, you're out of luck. Another thing to keep in mind is there's a federal injunction called Cooper versus Salazar. What that means is that the EEOC or the Illinois Department of Human Rights has to give you the benefit of the doubt. They do not make judgments based on whatever you tell them. They have to look at the evidence most favorable to you. Now, with any court proceeding or any proceeding involving any administrative agency, it always begins with a charge. To begin your charge, you have to obtain a copy of the charge from the website, and you have to complete it. Now, when you complete the charge, the important thing is to be as detailed as possible. Supply names of witnesses, dates. If you can even remember the type of suit somebody is wearing, the color of their suit coat, as specific as possible, that'll help your claim in front of the Illinois Department of Human Rights. Be as thorough as possible with the charge. Also, when you file the charge, the employer cannot retaliate against you. They are prescribed from doing so, and if they were to do so, they would only make a bad situation worse. Once the charge has been filed, the investigation begins. The Illinois Department of Human Rights will assign an investigator. They'll call you in, and they'll ask you a bunch of questions. They'll look at your charge form, which, by the way, has to be notarized, and they'll ask you questions about it. They'll ask you certain questions about when the discrimination took place, who were the witnesses, will these witnesses testify. They may subpoena records from your employer. They may subpoena testimony from your employer. The investigation is normally very thorough. And then finally, if they think there is enough there, they will file a discrimination charge. Now, what type of discrimination can you pursue? Under the law, you can pursue employment discrimination, pursue discrimination based on credit, housing, public accommodation, and sexual harassment in secondary education. I'm just really here to highlight a few of the key areas in employment discrimination, because that's the big one out there. That's the granddaddy of all discrimination. And by employment discrimination, I'm talking about race, color, religion, sex discrimination. I'm talking about discrimination based on age or ancestry, national origin, marital status, unfavorable military record, disability, and retaliation. These are broad areas. These are all areas you can pursue your charge of discrimination with, but again, let me come back to what I mentioned before. You have to recall that you have to pursue all administrative agencies, and you have to file your complaint within 180 days of the last act of discrimination. I hope this has been helpful. If you have any questions, please contact me at 312-546-5057, or you can send me an email at john@otoolellaw.net. Thank you.